Welcome to Civil Disagreements, a discussion about bail reform. I am Darcy Siegel, Chair of the American Bar Association Standing Committee on Public Education. In 2023, Illinois became the first state in the nation to eliminate cash bail. A year later, we want to take a look at what's going on and how it's going. We also want to explore what bail reform means realistically for a jurisdiction, as others across the country might be considering the same. This is the latest in a series of moderated discussions on current, critical, and often contentious civic questions sponsored by the American Bar Association's Division for Public Education, the American Constitution Society, Chicago chapter, the Federalist Society, Chicago chapter, and Reform for Illinois. Today's program will feature a moderated panel discussion as well as the opportunity for audience questions. Please share any questions you may have at the Q&A at the bottom of your screen. Note that Illinois lawyers may receive CLE credit for this program. Simply watch for a follow-up email shortly with instructions. Without further ado, I am pleased to introduce Raff Donelson, a professor at Chicago-Kent College of Law, who will moderate today's discussion. Raff, the floor is yours.
Thank you so much. I am very much looking forward to moderating our discussion between a number of distinguished panelists. So as Darcy said, I'm Professor Raff Donelson. I teach criminal law, criminal procedure, constitutional law, and legal theory at the Chicago-Kent College of Law. And I, as I said, am very pleased to moderate this discussion. So we will begin with Mr. Joe Tabor of the Illinois Policy Institute, followed by Sharone Mitchell, the Cook County Public Defender. And finally joining us will be Insha Rahman, who is at the Vera Institute of Justice and the Director of Vera Action. So Joe, if you go ahead and both introduce yourself and give us a few words about your take on bail reform in Illinois.
Sure. Well, first, I'd like to thank the American Bar Association, the American Constitution Society, the Federalist Society, and Reform for Illinois for hosting this discussion. And thank you to Tiffany for running the behind the scenes, to Raff for moderating, and to my co-panelists, Insha and Sharone, who have actual hands-on experience in this criminal justice space. My name is Joe Tabor, and I'm the Director of Policy Research for the Illinois Policy Institute. We are primarily a free market think tank, but we also have done research in the realm of public safety and criminal justice reform. We've helped pass laws creating a path for people who have served time to obtain licenses as healthcare workers. And we are working on legislation to make it easier for those on electronic monitoring to find employment. As was said, in September, Illinois became the first state to completely eliminate cash bail statewide. And I think there are three things that we should keep in mind when we discuss that historic first. The first is that crime is a top priority for voters, especially in Chicago, and for good reason. 58% of Chicagoans put crime as their number one or number two concern. And violent crime spiked 11% in the past year. Theft, robbery, assault, battery are all up since then. Carjackings and vehicle thefts have doubled from the pre-pandemic levels. And a lot of people want to lay that partially at the feet of the bail reform, the getting rid of cash bail. And I think part of the reason for that is that the process of passing the legislation was lacked a lot of transparency, and it was rushed through. There were things that needed to be changed in the law, and it just seems that there's a fog of confusion around what the law actually says among the public. And number three is that these problems cannot be laid at the hands of bail reform. Bail reform is intended for a different purpose. It's not supposed to be used to detain dangerous criminals, even though that's what we had begun to rely upon on it. It's not a good way to do that. Cash bail tends to punish people who don't have money and release people who can pay the fee. But even so, the details matter, and there's things that we could have done better in this version of the law.
Sharone, would you like to go ahead and introduce yourself next and give us a kind of brief take on your take on bail reform in Illinois?
Sure. You think 3 years, 4 years into the pandemic, I would learn to mute myself, but apparently not learn those lessons yet. But my name is Sharone Mitchell Jr. I work as the head of the law office of the Cook County Public Defender. The law office of the Cook County Public Defender represents the vast majority of people here in Cook County, which is Chicago and many of its suburbs. When somebody cannot afford an attorney on their own, they are appointed attorney from our office. And because the vast majority of people in the criminal legal system are poor, that means, unfortunately, that we represent the vast majority of people. So that is kind of our engagement with the process. I had some pre-prepared remarks, but the spirit has hit me to tell a story. Before, I've been at the public defender's office a couple of times. This is my second instance with the public defender's office. Between stays, I worked in policy, and I worked to help support some of the changes to the pretrial system. And during that time, I was kind of going to a lot of radio stations or news outlets and kind of talking about what these changes could potentially make. And shortly after the signing of the law in 2021, I think it was in March or April, I returned to a radio show. And it was one of these formats where they had one conservative and they had one a liberal, and they would kind of debate on the issues, right? And as soon as I got on the show, one of the members basically said, "Well, Sharone, you came on here and talked about in the cash bond, and you finally got what you wanted. And look what happened. There's all this crime that has happened because of the in the cash bond." We were talking at that time in March or April of 2021. What the host did not know is that the actual changes would not be scheduled to happen for 2 years, right? So they were commenting on kind of the increase in crime supported by the end of cash bond about 18 months too soon. And the reality of the situation is that's what's happened a lot, right? There's this idea that bond reform or bail reform is kind of this pro-criminal reform, and that there will be increases in crime just by its existence. And the actual facts and the realities don't really play into what has devolved into kind of a political discussion. I think Joe's right, though, that the details do matter. And the reality of the situation is, if we take a step back, shortly before the passage of this bill, there was a well-funded and well-organized and really well-targeted campaign that tried to describe the changes around the Pretrial Fairness Act. It was described as the purge. It was described by really, unfortunately, serious people with serious jobs, that the streets would run red with blood. Folks characterized the change as a deterioration of the criminal legal system. Well, we are now about 6 months into the actual implementation, about 8 months of the actual implementation. I just want to congratulate everybody on surviving the purge, right? The reality is that the changes in the Pretrial Fairness Act were common sense reforms. We can get deeper into what those reforms were, but the idea that we use money as a determining factor and whether somebody should be in jail pre-trial before any trial has happened was always a broken model. And whether you came from more of a law enforcement pro law and order space, or a more reformist or abolitionist, or there are too many people in jail space, everybody agreed that the system that we had before made no sense. So I'm really glad that we have moved into a system where judges are making these decisions based upon risk and not money. With that said, the Pretrial Fairness Act did not produce any crystal balls, right? It did not for judges. It did not. It didn't abolish the presumption of innocence, right? So there are going to be people, right, who are accused of an offense and then reaccused of another offense, right? Those stories definitely exist, and we know that there are members or media forums that are dedicated to telling the story of every failure. But the reality is, right, the vast majority of people who are accused of a crime come back to court, right, whether they are given a cash bond or not. And we know that oftentimes when we're discussing these issues, we rarely talk about the impacts on communities that the cash bond system presented. As a young public defender, one of the hardest things I ever had to do, or to do constantly, is talk with people from my community, mainly mothers, grandmothers, partners, sisters, women, about whether they would pay their loved ones bond or whether they would do the basic things they needed to do to survive, paying rent, things of that nature. The fact that we've eradicated this system, which served as a really one of the worst regressive taxes on Black and brown women, is quite frankly one of the best reforms that we could have taken on. And as we continue to move forward, there are changes that could be made. There'll be debates forever, but the reality of the situation is the system before the Pretrial Fairness Act was incredibly broken, and we're seeing significant benefits both in terms of public safety and fairness. So I'm really excited to have this conversation. Thank you so much to Joe. Thank you so much to Insha. And thank you so much to all the great folks that have put this debate together. And one thing I can say before I conclude is that I'm so glad that we have an opportunity to talk about the details and talk about what's really happening in this reform and push back past the politics of this issue and really talk about what it means to keep our community safe and make sure that our people who are accused of offenses have their constitutional rights looked after. So thank you so much, and looking forward to the conversation.
Wonderful, wonderful. And our third panelist, Insha Rahman. Insha, can you please just introduce yourself and give us a couple of minutes of your take on bail reform in Illinois?
Sure. Hi, everybody. Great to be here. Thank you, Joe, Sharone, Raff, and my apologies for joining late. Thank you for the grace of getting to go last, so I get to listen to these brilliant folks and build upon their thoughts. So I got my start in working on this issue as a young public defender as well. And as Sharone said, it is both devastating to have the conversation with a mother or a sister or a girlfriend or a wife, like, how am I gonna pay my rent? Or do I pay bail? Knowing that not paying bail is the biggest consequence for the end of that case and also for that person's life. And then there's the other piece of it, which take out the sort of personal human impact, which is incredibly important, and go to the system itself. Every time I watched a judge set $250 bail or $500 bail, I always ask myself this question of, is the judge intending for this person to get out because they think that they can make $250 or $500? As a public defender in the Bronx, it's one of the poorest counties in the country. People don't have $25, let alone $250 or $500. Or does the judge intend to keep my client in jail, in which case there should be far more due process than just setting a money bail amount before we take away somebody's liberty. So the problem with cash bail is, from perspective of the system, is that it obscures the real decision about whether somebody should rightfully be out or be in pending trial. So I did that work for a long time and then came to the Vera Institute of Justice, which is where I am now, in 2015. And I'm based in our New York office, and I work nationally on issues of bail reform. I'm the Vice President of Advocacy and Partnerships at the organization and have worked on bail for the better part of a decade, doing policy work. And I worked on New York bail reform. And it doesn't matter where you are in this country, if you've never stepped foot in New York, you have an opinion about New York bail reform because you've heard things. And chances are what you heard is not flattering. And let me tell you this, 4 years after New York bail reform has gone into effect, as a matter of policy, it's working. It's doing exactly what bail reform is intended to do, which is to take money out of the equation, especially for low-level offenses where people should just be going home. There's no actual threat to public safety. And it's making sure that when bail is in fact set because New York bail reform retained bail. It didn't really change the system for the more serious cases, the cases in which there are concerns about public safety, according to the allegations. What it did require judges to do is really consider ability to pay, and therefore that obscure decision of like, is that money intended to keep the person in or allow them to be released? We actually get to look at that decision honestly. So it's not a perfect bail reform, in my opinion, as somebody who worked on it, but it is a bail reform that is working in that public safety has not been affected in New York. There are multiple credible studies from multiple different universities and researchers who have looked at the rise in crime in New York in 2021, 2022, it's coming back down 2023 and into 2024. That rise in crime was not due to bail reform. They both happen to happen at the same time, but they are not correlated, let alone have any causation effect. And the other thing that we've seen is that bail reform has been good for justice in that there are far fewer people behind bars in New York today as a result of that reform. And the reason I start with talking about New York bail reform is because it was, I would say, the first to go and sort of experience the real political backlash that we know Illinois experienced after in 2022 during the midterm election cycle, the purge. I can put a hard number on it, which was in Illinois. Before the law had ever gone into effect, the opposition spent $40 million fear-mongering about the law. And yet what happened in Illinois that I think is remarkable as a matter of politics that didn't happen in New York, because the minute the backlash to New York bail reform started in 2020, the same legislators who enacted the law, who passed it, who celebrated it a year before, ran for the hills and said, uh-oh, actually, we didn't need to go that far. And they actually rolled back parts of the law literally within 4 months of it going into effect. And then we've been in rollback after rollback for 4 years. This is the first legislative session where there are no rollbacks to bail reform. So it is possible to get out of the bad politics, but you got to stay in there. It takes 4 to 5 years is what we're learning. In Illinois in 2022, when the political backlash started, we watched all those same legislators, everybody from Governor Pritzker on down to state legislators, actually hold firm. Maybe there were conversations behind closed doors, which were, uh-oh, what did we do? But publicly, it was support for the Pretrial Fairness Act and a reminder of why money bail is not just, it is not fair, and it is not a good system. And Pretrial Fairness Act went into effect in 2023, as we know, but at the end of 2022, during the midterm cycle, there was actually a poll that came out in late November, which asked Illinois voters, when it comes to bail reform, are you favorable, neutral, or unfavorable towards the law? 60% of Illinois voters said, even after $40 million worth of fear-mongering about the law, that we remain neutral or favorable towards the law. And it's because the politics held up around the law, supported the reforms, reminded people why we needed reform in the first place. And it's a really important lesson, I think, coming out of Illinois. And I know that we're a bunch of lawyers on this call, but I think we can't think only about policy or implementation or practice. We have to think about politics. We live in a world where politics is a very real thing. It's really important to think about the politics of these reforms and of implementation. And Illinois, from where I sit, is a great example of getting it right. I know there's a lot more work to be done. We're going to get into the details here. But I think that national perspective, and especially putting it in contrast with another law that has actually done what it's supposed to do, but doesn't feel that way, I think it's really important for Illinois to have started off on the right foot as a matter of politics. And from what I can see is continuing to actually hold the politics around the law, even as it goes into implementation. It will not be perfect, but we can see positive momentum, public support remains, and that is, I think, a really good thing for not only Illinois, but for other states to look to.
Great, 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 great. So I want to start with asking a kind of very broad question to maybe get more all the panelists involved, but also to drill down a little bit into some of those details. So all of you have spoken about some of the great things that this legislation does. Key thing is that it gets money out of the determination of who is to stay in jail awaiting trial. What do you think are some of the challenges or things that are not going so well with the bill so far? Like, what are things that, insofar as there is more work to be done, what is some of that more work to be done? What would you change, either about the text of the bill or about some of its implementation? What are kind of things left to be explored and worked on?
We're all being very polite. I am more than happy to jump in, but also Joe, Sharone, if you have things that come to mind, please. So I'll say as a matter of implementation, where we've seen bail reform statewide work is where there's been significant investment and building up of community-based pretrial services. And that has started to happen in some parts of Illinois, but it is pretty checkered, and there hasn't been, I would say, nearly enough money, nearly enough investment, and nearly enough sort of standardization of how pretrial services happens, so that judges actually have a choice in the cases where they have discretion about, do I release this person or do I detain them pending trial? Do I have another option? And I would say in the law itself, there are some good safeguards around when supervision can be imposed and when it shouldn't be, some safeguards around sort of not having permanent or endless supervision during the pretrial period. But in order for any of that to be a reality and to take hold, you've got to do pretrial services well. There are examples across the country. Again, I come from a national perspective to this. There's examples like in New Jersey, where as bail reform went into effect in 2017, the state actually set up office-wide pretrial services with each county or each jurisdiction having its own local office. They contracted with local community-based organizations, treatment providers, others to really sort of have a robust set of services. So whether you're arrested in the rural part of the state or like the big city, you're actually getting access to pretrial services. And that, I think, has still been slow to be properly rolled out across the state. And that's really an important implementation fight. And we know it's one that judges, law enforcement, prosecutors, as well as defense attorneys can get behind, given that people have better pretrial outcomes when they're supported, when their basic needs are met during the pretrial period to come back to court and to stay on the right side of the law pending trial.
I guess I can go next. With the implementation of the no cash bail, kind of some of the issues that we've been seeing are issues of resources for prosecutors, for courts. We've seen the appeals courts swamped with. It seemed like they were not expecting the level of appeals that they would get from the from petitions to detain pretrial. So that seems to be something that was not planned for. In addition, downstate Illinois does not have the resources that, for example, Cook County does, and they're seeing a lot of pressure is in the prosecutor's offices. We're seeing is that they kind of have to triage, and they're putting in a lot of work, and they're under a lot of pressure to get these petitions filed. Those are the kind of broad issues with the implementation of the bill. The other issues are with the public perception. Insha talked about how there was a campaign against the bill itself, and that's part of the reason that there's some misunderstandings about what the bill says. What is a detainable offense? For example, this is even in the case of prosecutors and judges. There was a case in Chicago the other day that where a prosecutor didn't know that attempted kidnapping was a detainable offense, and the judge didn't either, and so someone who might have been detained was released. I think a lot of this goes back to how the bill was passed. If I could take a time machine and go back in time and kind of change what happened back then, I think there should be a lot more transparency. The bill was filed as a 764-page amendment, and then it was passed an hour later after it was filed. with no debate over the bill, and people weren't given the opportunity to read it. In that bill, there was a lot of confusion in the bill itself. The language itself was unclear. It needed a trailer bill to kind of address the different standards that were expected of prosecutors. There were several different standards that seemed to conflict, that were confusing. They were able to implement a uniform standard, which was better. And there were a lot of gaps in what could be a detainable offense. So, for example, you would have a prosecutor in many cases would have to identify an individual who was put at risk by releasing someone, so a specific individual, and they changed that to make it so that a threat to the greater public was allowed to be detainable. So there were a lot of things that, as it was passed, it was rushed through. There were a lot of changes that needed to be made. Luckily, the legislature came together and were able to make some of those changes, and kind of put a balance to the threat to the public versus the rights of the defendant.
Yeah, so I might address a few things there. I think first, I think that the way the bill was passed certainly raised eyebrows. With that said, I might not go as far to say that it was, or maybe saying that it was rushed through may not be illustrative of all that happened, right? So the bill was first introduced probably around 2016, between 2016 and 2021, when it was officially signed into law. There were probably 3 to 4 subject matter hearings. There was a statewide working group. The Illinois Supreme Court issued recommendations in April of 2020 that included about 57 different recommendations, and most of the law was based upon those recommendations from the Supreme Court. That Supreme Court, if you look at the group that kind of made that task force, it was mainly prosecutors and law enforcement. Of the kind of 40 or so people on that group, there was one person from the public defender community and no people from the advocacy community. So I'm not, but with that said, there is certainly the idea that the final language dropped, very late in the night. There was debate, not a lot of debate. There was both a subject matter hearing the day before and a debate, but I totally get the point that transparency certainly was a piece. I just want to clear up that it didn't just pop up out of nowhere. I don't think Joe said that, but I think there has been some people that have suggested that this just kind of came out of nowhere. Listen, education is certainly something that exists, both in the community, in the public, and with the practitioners. Now, I will say that this law was signed into place in January of 2021. There were about 2 years and 8 months between the time that it was signed into law and the time it actually went into effect. So some of the errors in understanding the law, I think some of those may be intentional. I think others are just folks not doing the best job. To Joe's point, what he's referring to is a case where an individual was charged with child abduction, and there was a question from the prosecutor on whether child abduction was detention eligible. It seemed as if the prosecutor and the judge may have not known. Now, the funny thing about that story is that the person was detained anyway. Actually, the person was detained on another case. So that person was not released, even with the misunderstanding. We've got specific knowledge about that case, and that can, the public can kind of do their own due diligence on looking that up. But the reality situation, that's kind of an example, right, of this system that we've built. I would argue that it is not the most kind to people who are accused of very serious offenses. If you look at the amount of people who are accused of offenses, especially in the domestic violence context, you are looking at an uphill battle, unfortunately, when it comes to, and I say unfortunately because there's been no evidence, right, that you've been, actually guilty of anything, but, we are looking at, a serious consideration about whether you should be held or not. Compare that to the status quo, to what happened before the Pretrial Fairness Act, where if you had enough money, you were going to get out no matter what, right? So there have certainly been benefits in terms of, I think, having really more elaborate discussions and detailed discussions about detention, and we're not just relying on money. With that said, there was a trailer bill. That is definitely the case. There are several trailer bills actually that modified the Pretrial Fairness Act, but I would argue that was actually part of the design, right? One of the reasons why you saw an intentional 2-year runway was to actually ensure that there was more time to work out whatever changes need to be made, and you have to, I think, give credit to the sponsors of the bill that brought together both public defenders, prosecutors, the law enforcement community to make changes to the bill. I don't think that the structure of the bill was changed. There were some kind of changes to some of the standards, and I think that I'm not sure those standards were significant, but certainly there was a more elaborate standard, a more expanded standard when it came to threats to public safety. So in the end, I do think that there are some changes to talk about. One of the things that was been in the chat is the legislators' interest in helping to fund public defense around the state. While I certainly know that all stakeholders could use a little bit more support. If the prosecutors need a bit more support, I wonder what the public defenders are at. They get about a third of the support that prosecutors do, and probably have a harder job when it comes to these detention hearings. If you kind of really get into the details, they're not handed a police report that has the entire case to be made for detention, right? Or they've got to kind of really spend a lot of time and effort. With that said, I'm really glad that the legislator is looking at providing public defenders across the state more support and more independence. And I'm glad that the legislator has been looking into what Insha is talking about, providing more support for pretrial services. There's a kind of a more elaborate conversation around pretrial services, but certainly the state has really tried to invest in that, at least here in Illinois.
I next wanted to ask a question about assessment. All of you have spoken about the fact that there have been some who have made assessments informally of bail reform in Illinois, perhaps without a lot of detail, or maybe without it even going into effect yet. But I was wondering, how do we do assessments of this? When is the proper time to do assessments of this? Do you have thoughts about how we assess whether this is working, whether we need to make changes? Do you have kind of thoughts about how do we evaluate what actually counts as success in this area? Because there's always going to be new crime.
Yeah, I'll start here, and I promise you I will be much shorter than I was before. I saw a question in the chat from David Hiller who talked about evaluation, and I really want to point us to the great work done by our friends at Loyola University. It's tough for me as an Illini fan. A couple years ago, they bounced us out of the tournament. I was still, shout them out. Dave Olson and Don Steeman has done some great work around tracking the data around what's happening, and not just in Cook County. I think Joe brings up a great point that there are different experiences. People talk about there are 102 counties. Some people would say that maybe there are 102 criminal legal systems. There are actually probably thousands and thousands. And one of the good things that Loyola's done is really look at different jurisdictions, not just Cook County, and evaluating a number of metrics. Additionally, here in Cook County, we know that the chief judge has been collecting data and has made that data available on a data dashboard on his website. And we do know that there are other institutions that have been looking at the issue, including the Civic Federation and Chicago Appleseed, who've been looking at successes and failures.
So I would say the most important thing we can do is not judge success or failure by individual high-profile cases. If it is making the front page of the news, it is not a good measure of how the law is doing overall. It is simply a reflection of one high-profile, usually a tragedy, an awful incident, but that cannot be how we make policy or roll back policy or make changes. We've seen that done time and time again. So I'm in New York. We saw the 5, 10 bad cases sort of dictate the debate in early 2020. And New York legislature rolled back some of bail reform in April of 2020. The new rollback law went into effect in July 2020. What happened with crime? It continued to go up because there were other factors that were not bail reform. There was a pandemic. There was an increase in crime all across the country, not just New York. Kept going up, finally came down sometime around mid-2022, and it's continuing to go down. None of it had to do with bail reform. And so one of the sort of big cautions to legislators and policymakers and all of us who are part of the concerned public is to, make what you will of the high-profile, sensational case, but to not let that dictate what should happen with policy. There are things, though, that should dictate what should happen with policy. So when I think about what good bail reform looks like, there's essentially 4 things that should happen. The first one is that it should actually reduce the number of people behind bars. We are a country that doesn't matter where you are in this country, we incarcerate at a rate that is much higher than our Western peers. Pick Germany, Norway, France, any other country. We should just have fewer people behind bars and we will be just as safe as a result. So decarceration is an important first sort of metric to look at as we're looking at bail reform. The second is, are we taking money, wealth, and profit out of the equation as much as we can? And Illinois is to be seriously commended as the first state to fully eliminate money bail. New Jersey has functionally eliminated money bail. New York has reduced its use to just a fraction of cases, but to actually take out the money bail system. There wasn't a bail bond industry in Illinois anyway, but to actually, it's a clear shot across the bow to the bail bond industry, which is an industry that should die a quick death, in my opinion. There should not be profit over what is a public good, which is public safety. So taking money, profit out of the equation. The third is addressing racial disparities. It's hugely important because the cost of money bail and the weight of money bail doesn't fall equally upon all members of the public. It falls disproportionately on Black people and brown people. And we have to address racial disparities. And we've seen in places that have done bail reform and done it well, the burden of money and profit falls less on Black and brown people. What has still been challenging is who remains incarcerated. By and large, in New York, where I am, in New Jersey, in a number of other places that have now done bail reform for a handful of years, there has been a decrease in the jail population, but the disparities of who remains behind bars stay the same. So, for example, in New Jersey, the number of people in the jail who are Black was 54% before bail reform. It's 55% after. There hasn't, the needle hasn't moved on racial disparities, and that is something we've still got to work on. And then the fourth thing that is a measure of is bail reform effective or not is, has it maintained public safety? Is it consistent with public safety? And again, pointed to many studies in New York. I can show you those studies in everywhere else, both local counties and jurisdictions as well as statewide, where bail reform has happened. And in each and every case, public safety has been maintained even though bail reform has happened. So this idea of you can have safety or justice, but you can't have both, we've got to let go of that. That is a tired and false trope. It's a fallacy. It's not actually real. And we've got to look to the data to sort of disabuse ourselves of that. And so when's the right time to sort of do that analysis and look at those 4 metrics? I would say at least 2 years into a law going into effect. We give other things much more time to work, but given how high profile and contentious issues of justice reform, especially criminal legal reform, are, it seems to have a level of scrutiny that other things skate by, get much more leeway. And we need to give this kind of public policy the same leeway that we would give healthcare reform or education reform. We know things don't change overnight. unreasonable to expect that. And we need to, at least I would say, give it 2 years. And I think be willing to look at the data and see, are we doing enough to decarcerate, to address public safety, to address racial disparities, and to address the role of money and profit in the system?
Well, I agree that we should not be looking at individual cases, especially there's a lot of these cases where you'll see them sensationalized have more to do with things like prosecutorial discretion or than bail reform itself. It doesn't have anything to do with the cash, whether cash bail was available or not. And in many cases, as is pointed out, people who have the cash can pay it and then get out. And you've seen the same thing happen before the Pretrial Fairness Act was passed. I do think we should be looking at the data as it comes out, looking at the trends, just reporting on how things are going, and looking to see where we could do better. I think there's been some interesting arguments about the lack of detainability for things like misdemeanor assault, which is something that we can look into. I don't know. I'm against rushing legislation, so I don't think that we should immediately make changes. But it's encouraging to see that the Cam Buckner, one of the sponsors of the bill, is open to changes. The bill isn't perfect, and there are things that we could address. I definitely think we should be measuring is crime. We should be looking at where bail, people released on pretrial released, where are they committing crimes? Is it an increase in crimes based on people released? How much is it? Is it something that's acceptable? Is that a trade-off that we want to make? And ultimately that's up to the voters. The voters are going to decide, are we making the correct trade-offs between defendants' rights and public safety? I think that everyone is going to find that not tying pretrial release to how much your ability to pay. I think that we're all going to find that that's a better system. The level, what it takes to detain someone before trial, that's something that we're kind of looking at. Illinois is the first state to completely get rid of this system. So we're going to have to look at the data. We're going to have to look and see where's crime going, and look at the trends, and then make changes. And the public's going to be the ultimate arbiter on where that lies.
Wonderful, wonderful. If I were to add my 2 cents, I'd wonder also about the cost savings that we might realize, and also about how often people then show up to their appearances when they don't have this other inducement. I want, however, to get to some of the questions in the chat. So I'll ask a couple of these, but then I still may intersperse some of the questions that I have. So one of the questions asked, well, two of the questions actually have to do kind of with motions to deny bond, and also just kind of first appearances and how those have become more lengthy than they had been prior to the implementation of bail reform here. And I was just wondering, maybe any of the panelists, maybe particularly Sharone, insofar as your team is actually litigating some of these cases in court, kind of what has actually happened? Has there been a kind of explosion in the amount of time that these hearings are going on, because there's now questions about what, now there's questions about whether something's attainable or not, and then also questions about judges now having to pose the question in a way that they perhaps didn't before about whether the person is sufficiently dangerous to warrant detention, and kind of how is that affecting
Yeah, that's a great question. So, maybe about 7 years ago, the Sheriff's Justice Institute, which is a wing of the Cook County Sheriff's Office or policy shop of the Cook County State Attorney's Office, did a study and found that the average bond hearing took about 37 seconds, right? We were running bond hearings like we were renting the courtrooms by the minute. And that produced the results that you would expect, right? Essentially, and I think we were pulling numbers out of a hat, right? And the decision about whether somebody would get out or not get out would basically depend upon whether they had relatives who had the scratch to get them out. That wasn't a public safety winning. That wasn't a winning outcome for public safety. So while I push back on the idea that defendants' rights and public safety, and I don't think this was said, but sometimes it's been assumed that public safety and defendant rights are completely at odds, right? The system that existed before certainly gave accused people less rights and was also not creating great safety outcomes. With that said, and I want to shout out specifically, there are two great leaders of the League of Women Voters in the chat. That group, along with several other groups, I think did the hard work, and that is go into bond court, see what's going on, and then write about it. Right. And when that happened, I think people were horrified, right? That we weren't making, whether you agreed with the decision or not, right? We weren't creating a situation that allowed for the best decision to be made, or whether we're talking about, detaining a person or not. And knowing that detention of a person really has outcomes on public safety, right? The studies suggest that when you hold somebody pre-trial, that actually increases, right, risk to public safety, right? You disconnect people from their job, you can disconnect people from their work, their education. You just create a number of outcomes, right? It may mean a judge may decide that it's necessary to happen, but it's not a zero-sum decision to be made. With that said, you saw groups going into court, you saw court watching, you saw the Coalition in Money Bond, Illinois Network for Pretrial Justice, and other groups really publicize what they were seeing. And what you've seen after the passage of the Pretrial Fairness Act are decisions that are far more nuanced. You've seen longer hearings. In the Public Defender's Office, we've kind of changed the way that we're constructed to create a special unit, a pretrial unit that specializes in these hearings. And they've been assigned, investigators, or we're in those plans of assigning investigators so that we can make better decisions early on. So those are my thoughts on that. And maybe one more thing, just really quickly, and I'll get out of here. One of the great things about the system, right, and it's not perfect. I agree with Joe. It's not perfect, but it does create a very, I think, transparent decision-making process. So a prosecutor has to file a motion saying, I want to detain that person, and there's an argument about whether that person should be detained, right? Doesn't sound like that's incredibly, elaborate, or like seems pretty obvious, but that simply just wasn't happening. We were laundering decisions about detention through money, right? And we were just letting money to make the decision. And now we actually have a prosecutor having to stand up and say, hey, we're going to file this motion. And the prosecutor and the defense attorney actually make arguments, not in 37 seconds, but in 10 to 20 minutes possibly, about what should happen. And that's a system that we've seen work in states like New Jersey, which is not fully eradicated on money bond, but essentially eradicated money bond. So it's not kind of like this crazy experiment.
Raff, if I may just jump in, you had also
Please.
raised at the end of your last question, like, well, what about court appearance rates and things like that? And I didn't even think to mention that, because every single place in which we have seen bail reform happen, which by that definition I mean using money bail less or using money bail not at all, court appearance rates have either stayed the same as when there was a money bail system in place, or in fact they've gone up, because there are jurisdictions that have taken out money from the equation and actually set up good, effective, basic pretrial services. And one of the most effective ways to make sure somebody comes to court is a reminder, a text reminder, a phone call, works miracles. So I don't even actually put that into the sort of like bucket of should we be worried about this, because we have now seen literally years worth of evidence that shows people return to court. We need people to come to court for the courts to function. That does indeed happen if you take money out of the equation. But I do really want to sort of underscore the point, Joe, about this idea that, you know, the public is going to choose between defendants' rights and public safety. Because I think that, and maybe that's not what you said, so I see you shaking your head. I will not put words in your mouth. But I mean, I want to underscore the point that I said earlier, which is because there were real concerns about, is bail reform negatively impacting public safety? I trust that the New York legislators who went and rolled back the law in April 2020 were thinking about public safety, had the right concerns in mind. But if you blame the wrong causes, you miss the right solutions. And if bail reform was not the reason crime was going up, you can roll it back all you want, and you won't actually address the real concerns people have about an increase in gun violence or assaults or theft or any of the other things that people were genuinely worried about in 2020 are still genuinely worried about today. So I actually think there's a reason in terms of our duty to the public and to protect public safety to make sure that we are actually identifying the right causes and not blaming the wrong ones. And my worry about reform in general, but especially bail reform, is that it's very easy to blame. It's a good sort of like political hat trick, if you will, and rolling it back won't actually fix the real problem that people are genuinely worried about. So I do really want to underscore that point because I think it is a really important one for us in terms of public policy and what is for the public good.
So if I can step in, I just want to actually completely agree with Insha about this point. We've just passed bail reform in Illinois. We've had spikes in crime since 2020. The bill didn't take effect until September of 2023. The crime that people are upset about, that they're worried about, cannot be laid at the feet of the Pretrial Fairness Act. It can't. There's many other issues that we could discuss. This is about bail reform, but there's many other reasons why crime might be an issue, especially in Chicago. We have had issues with we have changes in prosecutorial discretion. We just saw a new election where, well, there might be a change, of course. There's also the issue of police vacancies. There's been a drop in the number of officers since Lori Lightfoot took office, almost 1,500 officers. That could potentially be a cause. Those are things that we should research. Those are things that we should look at. What are the correlations here? And get to the causes of sudden increases in crime that Chicago has seen, for example. I also want to echo the point that Sharone made about people in pretrial detention who are away from their jobs, who potentially getting fired, so they lose their livelihoods because they're held pretrial. And when that is tied to money, it's just completely unfair. So circle back in bail reform, there's a lot of things that we could talk about that changed, but tying your release to your ability to pay doesn't make any sense. And also the fact that you could lose your employment, lose your livelihood, also increases the risk of recidivism. So people who lose their jobs tend to also then are more likely to commit crimes. And so that it doesn't make any sense. This is one reason that we as an organization are looking into helping people who are on electronic monitoring. For example, currently in Cook County anyway, in order to, so you can only have one place of employment when you're on electronic monitoring. So you were released from prison on monitoring. You can only go, you're on house arrested basically, but there's exceptions for going to work and earning a living. But when you can only go to one single location and can't change locations, you're eliminating a whole categories of work. So we're looking into ways to remedy that situation as well. But I just wanted to echo that point that Sharone made.
We are just about at time. And so what I want to do now is thank our panelists, apologize to those in the queue who have kind of more questions to ask. There's so much more to explore with respect to this issue. But thanks, Insha, thanks, Joe, thanks, Sharone, for a wonderful and informative discussion.
Thank you so much for
Thank
having
you.
us.
Thank you.